ABC7 legal analyst Dean Johnson is here now to talk about this. Dean, no surprise, this was the expectation?
Yeah, no surprise, really. This is what we expected. The wording is also very much what we expected. The Supreme Court has developed some jurisprudence in these cases where it's looked at statutes and said, look, statutes that discriminate against same-sex couples don't even satisfy the most relaxed test we know of, what we call the rational basis test. And Judge Walker is echoing those precedents and saying that even though the rational basis test is a very low standard, this Proposition 8 can't even meet that standard.
Now, the judge mentioned two specific things. We have an advanced copy of the ruling before it's officially released. He mentioned two specific things that this violates.
Yeah, he talked about both due process and equal protection. Due process because the statute violates a fundamental right, and so takes away the right of people to be protected in their rights. Equal protection because the judge seems to be saying that sexual orientation is what we call a suspect class, and so because it classifies, Prop 8 classifies on the basis of sexual orientation, it's therefore also constitutionally suspect and can't get over the test that the court would impose upon a statute for constitutionality.
Dean, as we've sort of rifled through the portions of his legal ruling that we have, it's very clear that he was quite harsh, really, on the legal arguments for those in favor of Proposition 8. In one section here toward the conclusions, moral disapproval alone is an improper basis on which to deny rights to gay men and lesbians. That's from Judge Vaughn Walker.
Yeah, exactly, and I think that's the key quote, and I think Judge Walker putting that quote in is very strategic, because that was the central sentence in a case called Lawrence versus Texas, authored by Anthony Kennedy, who will probably be the swing vote on this case in the United States Supreme Court.
There's another part of this particular ruling. It says the evidence shows that Proposition 8 played on a fear that exposure to homosexuality would turn children into homosexuals and that parents should dread having children who are not homosexual. This was in the judge's ruling.
Yeah, you almost sense an angry tone in this opinion. When the judge and everybody in that courtroom looked at the campaign of fear and paranoia and prejudice that was behind Proposition 8, I think a lot of people were shocked. I think the judge was shocked. And I think what the judge is saying is that fear, paranoia, prejudice, private moral codes really aren't a rational basis for any legislation ever.
You know, it's very interesting to read the little excerpts that we have because, you know, I didn't witness the whole trial, obviously, but he really seems to shoot down very harshly the legal arguments made by proponents. Here he says many of the purported interests identified by proponents are nothing more than a fear or unarticulated dislike of same-sex couples. He almost seems to have dismissed a lot of the legal arguments for the ban.
It's not so much that he dismissed legal arguments, it's that there weren't really legal arguments. Time after time, when the Prop 8 lawyers were asked, well, what's the reason? Give me a reason that we can all agree upon. The response was either, well, we don't know the reason, or there were vague and kind of angry phrases like, well, same-sex marriage is going to contribute to irresponsible procreation or the deinstitutionalization of marriage. But nobody ever explained what that meant, and I think Judge Walker was as frustrated as was everybody else in the courtroom.
For lack of specifics.
Yeah. Exactly.
Dean, we have a lot more to talk with you about, so stay put, please.